Hi, everyone. Harry here to talk about Judge Aileen Cannon's dismissal of the Mar-a-Lago case against Donald Trump and his two co-defendants, Carlos de Oliveira and Walt Nauta. Let me just start here. She has been totally slow-walking it and serving Trump's purposes of keeping this case from actually being decided for a year. And this final sort of coup de grace, in a way, isn't even surprising. In a way, puts us out of our misery. I'll tell you what it sort of sets up soon. But you have to see this in the context of her whole really complete in-the-tank service to Trump, who appointed her as his last batch of judges after the election in 2020. Second, the ruling, and I'll get into this a little bit more too, is just, my op-ed, which we'll link to here, is, I think, accurate to say I started to sort of criticize all the legal analysis, et cetera, but that's not even the right point of view. The right point of view is to think of this as the first decision of Project 2025, where the rule of law completely takes a backseat to the preeminent principle of loyalty to Donald Trump. Okay, let's talk a little about what happens next, and then talk a little bit more about why the opinion is such a piece of trash. What happens next? Well, so this dismissal is on the ground that the appointment of Jack Smith, or really any special counsel within the Department of Justice, was not by law. And there is a provision in the Constitution that says if you have an inferior officer, we'll get a little bit more into what that means, the appointment, Congress can provide by law for them to be appointed and by, say, the head of a department, like Merrick Garland. But if they don't, then they need to be nominated by the president, confirmed by the Senate. The analogy for special counsel is U.S. attorney. I had that job. I had to be nominated and confirmed by the Senate. And it's an important, political check on the president and the possible use of, really rank cronies in that position, which, little aside here, is what we're surely going to see if Trump wins. The important point to note is it's not the end of the case. It's a dismissal because the special counsel didn't have authority. But even in a whole legal landscape controlled by Aileen Cannon, and we very much do not have that legal landscape in this country yet, there would still be the opportunity for the Department of Justice to refile the cases, either doing one of two things, including both. One is to not have it be by a special counsel, just have it be by in the regular U.S. attorney process. A U.S. attorney, say, in D.C. or Florida, files the cases. The problem there, even though Cannon has suggested this is the kosher thing to do, is, remember, we have a special counsel here for a reason. We're talking about the DOJ prosecuting the former president, and that screams out for some kind of added assurance of impartiality, lack of politics, and that's really important to Merrick Garland, and I think in his estimation to the country. So you've seen that suggestion bandied about, but just taking special counsels out of it is to take the assurance of impartiality out of it. I don't think that the DOJ is going to want to do that. And in fact, they've immediately appealed the decision already, which is lickety-split for approval of an appeal. The other thing they can do is still file it with a special counsel, but either in another district where they hope there'll still be good venue, that is, enough has happened there that it's okay to bring the cases, or to bring the case. That could be in D.C., or even in Florida, and do another roll of the dice. Or, relatedly, take an appeal, win the appeal, which they should do. I'll get to why that should happen shortly, and move to recuse Cannon. And if they do that, they can just come back to where they were. they can use a special counsel. That's assuming the 11th Circuit has reversed Cannon's opinion, and then they get somebody she's recused from the case. Would that be likely? Yeah, I think it actually would be. First, the opinion, again, I'll get to in a moment, is wrong as the day is long. But second, she's got such a track record here, and we have real reason to think that the members of the bench down there, conservative, liberal, whatever, are all see this as a terrible eyesore and her as a real embarrassment. They pushed her to get rid of the case before, and she didn't do it. Meaning I think that they'll take the opportunity, if they can, to recuse her. What would that mean? They would need, under the pretty strict law of the 11th Circuit, to find, A, that she got this one wrong, which I think they will, unless the 11th Circuit also goes upriver, and that B, this overall pattern, starting with her whole crazy-ass green lighting of Trump's separate action after the search to challenge it, and have executive privilege review and all that stuff, completely bizarre and unprecedented. The 11th Circuit sternly reversed that, and they can use that as a sort of predicate, the law of the 11th Circuit, as if there's sort of a pattern of bad and imbalanced holdings by the district court. You can use that to recuse. Okay, now let's just talk about the case a little bit. So here's the holding, as I said, is that Jack Smith, it's not, and it's important, she starts the opinion with all these august statements about the separation of powers and the appointments clause and all that stuff. It is not a constitutional case, okay? There have been constitutional challenges in the past to appointments of independent counsel. That's not what this is. Everybody agrees that the Attorney General, if there's a law passed by Congress that authorizes it, can appoint a special counsel. Now, there are reasons why it's better or worse as a practical matter, and those are the things that have been discussed sort of at length and played out. But the argument here, even though she says it's the vindication of the appointments clause, really all it is here are a few statutes. The Department of Justice proffers them and says, look, they give us authority. Congress said you can use them to appoint somebody to help you on a case. That means that under the constitutional language, you have the special counsel, an inferior officer. Congress has provided by law, that is, a statute, for their appointment. And so her holding, though dressed up in fancy constitutional garb, was really just saying each of these four statutes doesn't provide the justification that the DOJ says it does for appointing a special counsel to help out here. Now, this holding was, not simply kind of a surprise, but flies in the face of case after case after case, including the Nixon case, most importantly, 1973, where the court basically says that this is something that the Attorney General can do. More than basically, it says Congress has said that the Attorney General can do it, and she goes through this sort of tortured 10-page analysis about why that statement in U.S. versus Nixon that's been again and again invoked is, in fact, dictum, or a passing statement, she says, meaning that even though the Supreme Court said it in its unanimous opinion, it actually didn't figure in the holding. That just seems totally wrong. If you look at the holding of Nixon, if they had found otherwise, that there wasn't authority, I think, in fact, it would have mattered. So it's not what the lawyers call dictum. It is what they call holding. But the main thing is, it's just been taken as a canonical, statement since 1973. Of course, the power here does reside in the Department of Justice. So she is completely against not just a tide, but a torrent of opposite opinion. And also, the sort of stench of it is accentuated by knowing that in this recent immunity case, Justice Thomas did one of his lone concurrences where he basically, well, not different from his normal ones. Normally, he's known for his crazy kind of, I would hold there's no, enumerated rights in the Constitution, etc. What he did here was agree with everything that the majority had said, but then kind of in this weird academic, almost parlor room after dinner exercise say, but there's another thing I think I just want to talk about a little. I'm not sure it's right, but I want to talk about it. So that's the exact theory that Cannon took and, galloped away with. So, it's just not really even worthwhile to criticize it on its own terms as one normally criticizes legal rulings as a matter of precedent, as a matter of statutory construction. She's just way out there as a judge of one, and the conclusion seems inescapable that she's, wagering in some way on Trump's winning and that being her professional future. Certainly she won't have one otherwise. And of course, that's just so grievously wrong because what it means is, she's violated her oath to do justice, not having to do anything with the parties. And it's like just a really embarrassing and shameful day, but of a piece with what Cannon has been doing so far. By the way, remember, she's studiously avoided. She's got 9 different motions there that she hasn't even ruled on because she hasn't wanted to give, I think, the 11th Circuit a chance to reverse and recuse her. But now this is the smart play in just sort of crass Machiavellian terms, because now I don't think there's time for the 11th Circuit to reverse the holding, as they almost certainly will, before the election. So whatever sort of shot in the arm, and Trump went running with it right away about how, the beginning of the end of the attacks against him in the legal system, etc. She makes it now. It's true. I think her service to Trump is now at an end. Either she gets recused or the DOJ refiles charges in a way that keeps it 99 miles away from her. But, the account is paid in full. She's done all she could, short of just starting the trial and then, trying to end it in the middle so there's double jeopardy. So, it's a really just egregious, shameful episode, just in the annals of the federal judiciary, but it's properly seen, I think, through this vantage point of what has she done for Trump lately and what might he do for her. And she's done all she can. She's dismissed the case in a way that will hold until it's reversed, and that will be almost certainly it would be after the election. You can imagine a state of play where the DOJ right away files elsewhere, but that's not happening. Because I think the reasons I said, they really care about this principle of appearance of neutrality where prosecution of Trump is concerned. And so they have already immediately, and there's a whole process here, and it went lickety split. They've already authorized the appeal. So it looks like that's the route they're going to take. Appeal to the 11th Circuit ought to be reversed. She ought to be recused. But of course, by then, if Donald Trump has been elected president, the whole thing is moot, because he will, in his, completely Trumpian corrupt way, just instruct the Department of Justice to make this case go away, and he'll have the power to do that. So it's a tawdry, embarrassing, really, violative of her oath kind of, not just, yesterday's the culmination of all of that stuff, but you trace it back to when she first, is importuned, and it takes the offer by Trump to get involved in the case. And man, oh man, it is really a case study in judicial dereliction. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.